E ku iluna. Please rise. Ohea o ko e ko ka aha. Inahe kuliana I mua o kea aha. Ho o kolo kolo ki e ke hano hano o ka moku aina o Hawaii. E nawe mai, e malio mai, I lohe ia ka leo. Hear ye, hear ye, hear ye. All persons having any business before this Honorable Supreme Court of the State of Hawaii, draw nigh. Give your attention and you shall be heard. Inoho ilalu. Please be seated.
All right, please call the case.
Case number SCAP-22-0000371, Linda K. Rosehill et al. Versus State of Hawaii Land Use Commission. Arguing for Appellant State of Hawaii, Douglas Chin. Also arguing for Appellee County of Hawaii, Deputy Corporation Counsel Mark Disher. Also appearing for Appellant State of Hawaii, Christina Ohira, Eric Robinson, and Corey Terayama. Arguing for Appellees Rosehill, Calvert Chipchase. Also appearing is Christopher Gooden. Argument on the merits.
All right, good afternoon, aloha everyone on this very rainy, chilly afternoon. Our proceeding today is being broadcast live on the Judiciary's YouTube channel as well as on Olelo. I'd like to welcome our substitute justice, Judge Jeanette Castagnetti. Counsel, are you both ready to proceed?
Yes, sir.
All right. We've allowed 30 minutes for each side. Mr. Chin, you'll have 20 minutes. Mr. Disher will have 5 minutes. Mr. Chin, you reserve 5 minutes for rebuttal. Mr. Chipchase, 30 minutes with the 5-minute warning light. Mr. Chin, please proceed.
Chief Justice Rechtenwald, Justice McKenna, Justice Edens, Justice Ganoza, and Judge Castagnetti. May it please the court. Short-term vacation rentals are not an expressly permitted use as of right in the agricultural district. The definition of farm dwelling in HRS 205-4.5 contains no express language providing for short-term vacation rentals as a use, even though other uses a few lines down from there talk about overnight camps, overnight accommodations, visitors, tourism, and rental housing. Speaking more broadly, the legislature has never affirmatively added short-term vacation rentals to the list of 24 permitted uses available as of right in its section 205-4.5, or to the 17 uses in section 205-2. That's a total of 41 available uses, many of which overlap. What the landowners want to do here would effectively add a 42nd use and potentially open the door for short-term vacation rentals to legally operate in the agricultural district, even though the legislature, state, and all 4 counties have never expressly authorized or approved of this. As section 4.5b states, uses not expressly permitted are prohibited, except for when and unless a special permit allows such use. In my remarks, I'd like to explain why the commission decided that a farm dwelling may not be used as a short-term vacation rental. The reasons are, first, that use has not been expressly or affirmatively permitted. Second, the commission's own rules disallow it. And third, such a commercial resort of precious agricultural lands is incompatible with a district that the commission is constitutionally and statutorily obligated to protect. But first, before we get there, a word about jurisdiction. By law, the declaratory order issued here should have been directly appealed to this court. That's not what happened. Instead, the 16 landowners appealed to the circuit court, and when the circuit court, which we can all agree had no jurisdiction to decide this matter, sided with the owners, the commission appealed to the ICA, which we can also agree lacked jurisdiction. After briefing was completed, the petitioners applied for transfer to this court. The state objected, first because the statute and Appellate Rule 60.2 only allow transfers of cases within the jurisdiction of the ICA, and this case was not. But second, we also wanted to clarify a somewhat muddy record. For instance, in this matter, we are identified as the appellant, but because this is a direct appeal, we are not. We are here defending the Commission's authority as a subject matter agency and its issuance of a proper and legal order. As to whatever burdens typically apply to an appellant, such as the responsibility to bring an appeal to a court of proper jurisdiction, that would apply to the landowners. We also flagged that had this been a direct appeal, our briefing would have been different if we were defending the Commission's actions rather than reacting to and criticizing the Circuit Court's analysis.
So what relief do you seek? I know you have a pending motion to remand. Are you arguing for that? And what do you want from the court at this point? Do you want us to dismiss the appeal, remand to the Circuit Court, to dismiss the agency appeal? And if so, would this matter continue, or would it be over from your client's point of view?
That is what we asked. We asked that it actually be vacated and brought back down to the LUC level. What we did ask that at that time is we said all sides would reserve their argument and then be able to proceed from there, and then we could build the record on appeal from that point. As it stands, we are here now. We do not dispute the fact that this is the right court to hear a direct appeal of a land use commission order. And so if there are no further questions, I'm ready to move on to the
So
substance.
just to be clear, so you're not arguing that the Rosehill petitioners have no remedy if that were to take place?
No, we understand. Yeah. Thank you, sir.
I'm sorry, you said we understand that?
No, we understand we understand that we are here arguing right now on the direct appeal, and we're ready to proceed and argue with proceed with the order. All right, thank you very much. As this court stated 14 months ago in the Helco case involving Huhonua, a subject matter agency, and at that time it was the Public Utilities Commission, but here it's the Land Use Commission, must perform its statutory functions in a manner that fulfills the state's affirmative constitutional obligations. That is exactly what the Commission did here. Article 11, Section 3 of the Hawaii Constitution says that the state shall conserve and protect agricultural lands, promote diversified agriculture, and assure the availability of agriculturally suitable lands. It further states the legislature shall provide the standards and criteria to accomplish the foregoing. The legislature did so when it passed HRS 205-4.5 and 205-2. With respect to Section 4.5, the legislature has visited and revisited that section dozens of times. In those dozens of times, it has never expressly authorized short-term vacation rentals as a use in the agricultural district.
Mr. Chin, may
yes.
I ask you this question? In terms of the LUC's decision, it clearly granted the county's petition, denied the Rosehill party's petition. In terms of granting the county's petition, is it your position that all short-term vacation rentals of any kind are hereinafter barred by that ruling?
The factual situation was that the short-term vacation rentals that applied under Ordinance 18-114 of the Hawaii County Code, those, according to the LUC, did not fall within the definition of a farm dwelling.
What about that part of its ruling where it said, the Rosehill petitioners didn't present factual circumstances related to its petition such that it was a speculative request? Has the LUC left open the possibility of petitioners, whoever they may be, to go back and to present factual circumstances that might come within the definition of a farm dwelling?
Well, I suppose it would depend on how this decision ends up.
What do you think the LUC's decision was?
Oh, as far as the LUC is concerned, they did, because they denied the landowner's petition on the grounds that it was speculative and hypothetical without even reaching the question. I did want to point out that more to the point, with respect to Section 4.5, the legislature has never provided for short-term vacation rentals in any definitions or descriptions of a farm dwelling. Yes.
Mr. Chin, what's your response to Mr. Chip Chase's argument that the statute on its face allows that farm dwelling, single family dwelling located on an accessory to a farm, and the statute appears to, and it does expressly refer to leases. So I think their position is, as long as it's located on a farm, it can be leased. It's maybe a bit simplistic, but how do you react to that? What's your answer to that argument?
I think the reaction is that Mr. Chip Chase's argument is essentially trying to introduce an entirely new use into an already existing one. So we're not just talking about some sort of action or conduct that might occur on a farm dwelling. We're talking about a use. And perhaps a better way to think about it is the short-term vacation rental program that was introduced by Ordinance 18-114. And without question, according to the facts provided by both the landowners as well as the county, that is the reason that that the questions were brought in front of the Land Use Commission.
So
and in respect to,
I'm sorry.
no, I'm sorry. No, go ahead.
What about the argument that farm dwelling is it ambiguous? And if so, was that the basis for the LUC to exercise its expertise? Is that part of your argument?
Well, they did both, and the reason I can say that is because in looking at their order, when they described the standards of review that they were following, they not only talked about plain meaning, but they also talked about ambiguity and said that both of those tools were being made available to them in order to be able to make their decision. In fact, this is something that the Commission found in their finding of fact number 64. This is also how they analyzed the issue of short-term vacation rentals and farm dwellings. They said short-term vacation rentals are not listed permitted uses of a farm dwelling under HRS 205 and therefore are prohibited. In addition to the legislature never affirmatively authorizing short-term vacation rentals in the agricultural district,
Okay.
neither
So
is
can
this
you come
court.
back to the
Yeah.
I didn't mean to touch you
Oh, yeah.
short. Farm dwellings means single family dwelling located on an accessory to a farm. There is a recognition that such properties could be leased. And I think the argument further goes, there is no limit on the term of the lease. Therefore, it could be leased for a week, as long as it remains on the farm. And it's still a dwelling.
Thank you.
I think that's the argument. So what?
That is the argument.
Okay, and why is that not a meritorious argument from your point of view?
The reference to leases, it comes up twice in section 4.5. The first one is with respect to instruments of conveyance. And so when it's saying that a deed or a lease or a mortgage or an assignment of sale or any other instrument of conveyance occurs, it shall contain all of the restrictions that are listed for permitted uses within the agricultural district. That's not the same as saying that a farm dwelling can be leased. There's 25 other potentially available uses for leases. Moreover, the only other reference to a lease in section 4.5 occurs later on when it's talking about the type of lease that can occur when there's a subdivision of an agricultural lot. And in that instance, farm dwellings are actually one of the exclusions of something that can occur when you have that lease. And also it's for a term of 5 years. In addition to the legislature never affirmatively authorizing short-term vacation rentals, neither has this court. In fact, this court, since 1982, has analyzed section 205-4.5 no less than 5 times. In 1982, we had the Waianae Neighborhood Board case. That's when a 103-acre theme park at Kahe Point was not considered an expressly permitted use within the agricultural district. In 1990, we had the Maha'elepu case. That was the golf course case, which at the time required a special permit. In 1998, we had the Curtis case, and that's when a cellular phone tower was not considered a, quote, utility line, and it was not expressly authorized as of right. And in that case, the Supreme Court said that the idea of deciding that a cellular phone tower was the same as a utility line, quote, unreasonably expands the intended scope of this term. Fourth case, 2005, is the T-Mobile case. That's a stealth antenna inside the chimney of a farm dwelling. Okay. And so the stealth antenna did not fit the usage of a farm dwelling because it was not accessory to agriculture. Although the court did find that the same setup did apply to a different usage. It did not apply to a farm dwelling because the stealth antenna, which was being evaluated, was not serving agriculture. And so I think there's a potential parallel there. And then finally, last year, the Supreme Court decided the Ho'omoana case regarding outdoor camping, when the majority decided that because it was expressly excluded, then a special permit was not available at all. In the Ho'omoana analysis, there was a description of the three buckets that could be, in fact, this was the state's argument, but it was the three buckets that could be looked at in order to be able to decide how to evaluate a use. So the first bucket would be if it's expressly included, then it's available as of right. The second bucket is if it's expressly excluded, and then the majority decided that you couldn't even get a special permit for it. The third was when the use was silent, and the statute didn't say anything about it. And in that case, it was prohibited. However, if it was a unusual and reasonable use, then under 205-6, there'd be the potential to be able to get a special permit. In these 5 cases over 40 years, there is a consistent through line where this court always conducts their analysis by asking, does section 205-2 or section 205-4.5 expressly allow this usage? Or as the court stated last year in Ho'omoana, the language of the statute is the starting point. Putting aside farm dwelling, a survey of other permitted uses in the agricultural district that relate to housing or shelter or visitors is instructive. So in sections 205-4.5, there's employee housing. There's also open area types of recreational uses, which would include day camps, but not include overnight camps. In 2006, the legislature added plantation community subdivisions. That usage includes express provisions for new employee housing units and explicitly states those employee housing units shall be rented or leased at affordable rates for agricultural workers. That's an example of the legislature adding a usage and then expressly providing for rentals or leases. Also in 2012, the legislature added agricultural tourism programs for visitors, including accommodations of 21 days or less under certain conditions. That's another example of the legislature adding a usage and then expressly providing for overnight accommodations for visitors. While there are multiple express references in section 4.5 to overnight camps, overnight accommodations, rentals of housing, tourism, and visitors, none of those show up in the definition of farm dwelling. The same goes for section 205-2, except that in addition to what I just described as far as those different uses which overlap, 205-2 also makes clear that farm dwellings must be an accessory to bona fide agricultural services.
Let me ask you that. So moving to there, what if there's a short-term vacation rental and it doesn't sever the agricultural use of the property? So say, for example, there's somebody from the mainland who wants to come in, get a taste of coffee farming, say on Hawaii County, and they agree to work at a farm for, let's say, 3 weeks, nominal room and board. How does the law treat the dwelling? Is that an accessory to the farm?
Sure. I think our first response would be that farm dwellings don't have a provision regarding short-term vacation rentals. Another response would be there's a good way to think about that as employee housing. So in other words, workers that are there are also serving a different usage, which is
okay.
serving as
And so the
employees.
analogy would be to employees, but let's say he's not really an employee. I mean, I'm there. I want to learn a little bit about this, not agricultural tourism, and I'm paying a nominal fee. It's short term. It seems like your position would preclude that.
Well, I suspect that employee housing might be the next declaratory petition that goes in front of the Land Use Commission in order to test out that exact fact pattern. In other words, employee housing isn't defined, farm dwelling is. And when farm dwelling is defined, it has no specific provision for overnight accommodations, unlike the other usages that the legislature considered, vetted, and then added.
So this
in
might,
law.
in my example, it's sort of an educational front, or maybe I want to learn, protea farming or something like that. I'm coming in, here's this dwelling on this property. I'm only going to be here less than 30 days. I guess from what I see what you're saying, Mr. Chin, is that something maybe the LAUC would consider on a fact-to-fact
Right.
basis?
It also sounds like agricultural education, which is another usage. I don't think agricultural education necessarily has overnight accommodations as a provision, and I would grant that. However, I think that's why it goes back to what 205-4.5 says at the very beginning, which says the permitted uses of this land are restricted to the following expressly permitted uses. And then it says uses which are not expressly permitted are prohibited.
Are Airbnbs allowed? Like, say the person lives, the farmer, actually lives on the property, rents out 4 rooms. Is that allowed?
Well, I think that would first, I start worrying because I don't speak for the Land Use Commission, even though I'm the lawyer. But I do think that that's different in the sense of it doesn't fall within the short-term vacation rental program that was issued under Ordinance 18-14 because that owner lives there. Whereas under the short-term vacation rental program, then one of the elements is that they don't even reside.
I mean, because it strikes me that all the policy reasons that you have set forth are sort of undermined by a situation where somebody perhaps converts a farm dwelling into an Airbnb. Now, of course, in that situation, the person will have to be living there, but they could still rent out 4 rooms at, under 30 days and keep it rolling. Do you think that would be allowed?
I don't think it would be allowed under the statute as it's written, and the reason for that is because first of all, the language of the statute says what it says. In other words, farm dwellings did not add in short-term vacation rentals as a potential use for that. There might be other usages that are available where it could fall under that, but not farm dwelling. And so there is an option. There are other options to be able to address that situation, such as getting a special permit to be able to allow something like that, or to be able to get a change of the legislature to be able to expressly add that provision. I do see that my time has expired.
We'll hear from Mr. Disher then. Thank you
Okay.
very much, Mr.
Great.
Chin.
Thank you.
Good afternoon, Chief Justice, Justices,
Good
Judge.
afternoon.
I'm just going to jump right in. I only got 5 minutes. So the ROSEHILL petitioners, they make a lot of hay in their briefings in this case on the fact that the county conceded that their single-family dwellings on their properties are farm dwellings. The simple fact is that the only single-family dwellings that are permitted on agriculture lots that were established after June 4th, 1976 are farm dwellings, as defined under Chapter 205. It's the location of the house that defines it as a farm dwelling. And as such, the law requires these houses to be used as such. Located, so that means they need to be located on, accessory to, or some kind of connection to a farm. Not just on farmland, but a farm. And it houses a family that makes a living from agriculture activity. So yes, the county considers these single-family dwellings to be farm dwellings based on being on agricultural land established after June 4, 1976. And as such, these property owners are expected to follow the law regarding their use. As such, any other use not permitted under Chapter 205 would be a violation of state law. Now, as such, the passage of the county ordinance regulating short-term vacation rentals did not really change anything for agriculture properties established after June 4th, 1976. It was illegal for these properties to use farm dwellings for transient accommodations before the ordinance, and it was illegal after the ordinance. In fact, the ordinance and the resulting rules taken together with Chapter 205 basically indicates these properties need not apply. Now, however, due to the insufficient facts on the record, it is unclear how the properties were actually being used or proposed to be used, even though counsel for the Rosehill petitioners was directly asked by the LUC. Thus, the LUC is forced to assume or speculate facts regarding how these 16 different properties are being used to address their very narrow duration question.
Mr. Disher, I'll ask you the same question then. Has the LUC left open the possibility for petitioners to in fact appear before the LUC, bring facts before it that in fact dwellings located on farms are being used in connection with farms, but being rented out for less than 30 days? Is that door still open in your mind?
Arguably, it could be. I mean, they basically, during the hearing, were asking for the facts. I can stand here today and I can think of 5 different fact scenarios that will still be related to the duration question that could have varying answers from the LUC. And that's part of the point. I mean, what should have been presented to the LUC is how are each of these 16 properties actually being used? Is there agriculture activity going on? Is it a farm? That's one of the elements of a farm dwelling. And who is residing in these properties for such short periods of time?
Who is residing? Does the time period, is the time period, the end all question here?
Not at all, actually. Of the scenarios that I thought of, usually doesn't matter what the time period was. The only one that had a time period was basically the agriculture tourism scenario. So there's agriculture activity happening on the property. However, the dwelling is housed with visitors. However, those visitors are not contributing to the agriculture activity. They're not employees. It's not employee housing. They're paying the owners to vacation there. And it's not specifically allowed in Hawaii County. It's only allowed in counties with 3 or more islands, i.e. Maui.
Right.
So, and that has a duration limit of 21 days. That is the only one I would say that does have a duration number.
Well, that's part of Mr. Chin's argument, right? Is that how can you define farm dwelling to include short-term vacation rental when in fact the legislature has provided for specific other express uses?
Exactly. The position of the county is between the ordinance and the law of farm dwellings as it applies to these agricultural lots after 1976, it's apples and oranges. Yes, they're both fruit, but they're entirely different. The ordinance only specifies that it is for regulating legally existing short-term vacation rentals. That is actually one of the requirements. It has to already been legal. So it's the position of the county that these properties are illegal. Even if this court today adopted the reasoning of the circuit court, I believe the Hawaii County would still deny these as non-conforming use permits, because that begs the question, why, if they're using the farm dwellings as intended, are they seeking a non-conforming use certificate? Obviously, they're not intending to use it as it is intended. And so that's basically where we're at. I mean, and of the other scenarios that I can think of, there's the one that everyone's concerned about. There's the no agriculture activity occurring on the property, and transient residents are in the dwelling. This is your short-term vacation rentals. Obviously, this would not be permitted. Any use involving no agriculture activity would be not unless it's expressly allowed in some other section under 205, it wouldn't be permitted.
Anything further at this point?
Oh,
You're
no.
good over.
I'm sorry.
If you had anything to wrap up, or?
No, that is all.
All right. Thank you, Mr. Disher. Mr. Chip Chase.
Yes, Your Honor. May it please the court, Cal Chip Chase, and with me is Chris Gooden. Justice Ganoza asked whether there's any door left open for petitioners or anyone else. Justice Edens offered a series of hypotheticals to probe the universality of the county's rule as applied by or interpreted by the Land Use Commission. There is no door open. There is no room. There is no example. And the county itself made that clear on the record before the Land Use Commission. the county was asked, if you have a farmer renting to another farmer for the purposes of farming for less than 31 days, is that a legal use? The county answered no. That would be regarded as a short-term vacation rental. The county was also asked, well, what if you have a tenant who is not farming, who is never going to farm, but leases for more than 31 days, a trivial period, say 40 days? Is that a lawful use? The county said yes.
It's a lawful use or unlawful?
It is a lawful use. It doesn't matter under the county structure what the tenant is doing. It only matters under the county structure how long the tenant is there. So the farmer renting to a farmer for farming for less than 31 days, according to the county, as adopted by the LUC in its definition of short-term vacation rental, is illegal.
Are those findings or conclusions of the LUC in this case?
They're expressly stated in two ways, Your Honor. First, in the record, they're expressly stated. In the findings themselves, they're expressly stated in the comparison that the LUC made between the county ordinance and state statute, chapter 205, as of June 4th, 1976.
So which findings and conclusions
You
are
could look at
referring
80 to 83, Your Honor.
80 to 83.
You could look at to 80 to 83. And if you look there, look too at 76 and 79. Those findings collectively illustrate the arbitrariness of the LUC's decision in this case. At 76, the LUC recognized that what the Rosehill petitioners had asked is to compare state statute 205 as of June 4th, 1976 with the county code 18114 and determine whether there's any conflict. In other words, determine, as the counsel for the county just argued, that this use, this rental, for any purpose of less than 31 days was illegal as of June 4th, 1976. At paragraph 79, the commission finds that it can't grant that request to compare the ordinance and the statute because it's speculative, saying that there is no existing situation and there's not likely to be one. Immediately after saying that, at finding 80, in granting the commission's petition, it goes on to compare the state statute and the elements of the county ordinance. After that, it goes on to answer a question that no one asked the LUC to answer, and that was whether the county could be more restrictive in its regulation of state agricultural land than the state. After answering a question that no one asked it to answer, the LUC goes on to grant the county's petition. In granting the county's petition, coming back to your question, Justice, we look at what the county asked. The county asked whether short-term vacation rental, as it defined that term, as the county defined that term, was illegal as of June 4th, 1976. In saying that it was, the LUC imposed a rule that no farm dwelling can have the elements of the county ordinance. Those elements are rented, so not owner-occupied, 5 or fewer bedrooms, and rented for 31 days or less. There was never any dispute that a farm dwelling may be rented. Indeed, it's in the statute. There was never any dispute that a farm dwelling may have 5 or fewer bedrooms.
I couldn't hear.
Oh, I'm sorry. There was never any dispute that a farm dwelling could have 5 or fewer bedrooms. The only thing that was in dispute is whether a farm dwelling could be rented for less than 31 days as of June 4th, 1976. If it couldn't, if that was illegal as of June 4th, 1976, then it is true, as counsel represented. All the county has done is duplicate what was already the law. If that is not true as of June 4th, 1976, then the county is being more restrictive than state law. The county may be able to do that prospectively from the date of the ordinance forward. It can't do that retroactively. It cannot say that properties created after this date could not and could never have been rented for 31 days or less. It's that decision by the county to reach back in time that led the petitioners and the county to petition the LUC and to consolidate their petitions and to present the same facts before the LUC, namely the ordinance.
So let me unpack that a little bit.
Yes.
Wasn't it the ROSEHILL petitioners' position that at the LUC that the facts didn't matter? Was that your folks' position there?
Not at all, Justice. Not that the facts didn't matter.
That the use of the facts related to the use of the properties
The
did not matter.
specific uses of individual properties did not matter because that was not the question before the LUC, either on the ROSEHILL petition or the consolidated county petition.
Okay.
The fact before the LUC was the county ordinance 18114.
Right. Okay. You've gone through the 3 requirements as defined for what a short-term vacation rental are under the ordinance, none of which though address what type of use of the property.
Exactly.
Isn't that part of the challenge here, the issue that the LUC had?
Not at all. Not at all, because neither petition was property specific. The Land Use Commission was not tasked by the county with evaluating whether every farm dwelling in the county of Hawaii was a lawful use of the farm dwelling. The LUC was not tasked with evaluating whether the specific ROSEHILL properties were lawfully using them as farm dwellings. Those were not the questions that either party asked of the Land Use Commission. In calling the ROSEHILL's petition speculative and the county's petition not, the LUC has somehow made it seem as if the broader you reach, the less speculative it becomes. Quite the opposite is true. The more properties you involve in now announcing what has become or what is a universal rule in the county of Hawaii, that no property that was created after June 4th, 1976 may be rented for any purpose for less than 31 days. You've applied it to every single property, every single farm dwelling.
And why is that an unreasonable rule? Or
It's
why
a-
is that an unreasonable reading of this 204-5?
So we can then turn to the statutory interpretation portion of this. And we start with the text, as this court said in Kali'ipuleole in many, many cases. If we look at the text of 205, we see a couple of things. One, it is focused on use, not duration. It defines a farm dwelling by how it's used, not how long it's rented. Second, the legislature specifically contemplated leasing of farm dwellings, but did not impose a minimum rental period for those leases. It provided other conditions that must be in them. A minimum rental period is not among them. If we contrast that with the county ordinance, it's not focused at all on how the property is used.
But what non-conforming use was your client requesting?
To rent for less than 31 days. The only reason that the
You're taking the position that the statute, so you're saying to rent for less than 31 days pursuant to the ordinance.
Yes, Your Honor. So the way the statutory structure, the ordinance structure, I should say, worked. All properties currently renting for less than 31 days had to apply for non-conforming.
But this was for a vacation rental.
It was for a use that is less than 31 days. That is correct, but it is not limited to or does not necessarily mean vacationing, because the county ordinance has nothing to do with how the property is used. As the county explained to the LUC, it doesn't matter whether the tenant is farming on the property on a lease for less than 31 days, or the tenant is vacationing for less than 31 days. They're both illegal under the county ordinance. Conversely, it doesn't matter if the tenant is farming for more than 32 days or vacationing for more than 32 days.
And are you conceding that it has to be a farm dwelling used for farm purposes?
Yes, Your Honor. And so that takes me actually back to the CJ's question to counsel. No matter how long it's rented, does it need to be used for the purposes stated in Chapter 205? Absolutely. Chapter 205 states how the property is to be used. That is unequivocally true. Whether it's used that way for a day or 1,000 days doesn't change Chapter 205. At the same time, how the property is used doesn't change the county ordinance at all. It could be used for farming or for vacations. It doesn't matter to the county under that ordinance. All that matters to the county is how long it's used. That's the problem with the county reaching back in time. The only way it can do that is if we read into Chapter 205 a limitation that as of June 4th, 1976, no farm dwelling in the state of Hawaii can be rented for any purpose for less than 31 days. Any other answer means that the Rosehill petition should have been granted and the county petition should have been denied. And if we think about the consequences of that decision, what if the county of Maui, or even the county of Hawaii in the new ordinance, decides that as of June 4th, 1976, no farm dwelling can be rented for less than 6 months? Then anything less than 6 months is a vacation. Does that then mean that no lease on any property created after that date can be leased at all for any purpose for less than 6 months? Or if we take it outside of the context of agriculture and we put it in the city and county of Honolulu, if the city and county of Honolulu comes out with a rule that says no rental of any residential dwelling created after the residential dwelling zoning was established may be rented for less than 90 days, because we consider any other rental period in the residential district from the date of inception to be an unlawful short-term use. That is effectively what the county did here.
Mr. Chipchase, can you just explain so I understand your argument fully? The ordinance, I believe, refers to short-term vacation rentals, correct?
In the title, Your Honor, but not in
Okay.
the text.
So your suggestion is that that language is irrelevant or surplus?
My suggestion would be two things, Your Honor. First, when looking at the title of measures, whether they're a county ordinance or a state statute, we only consider them if the statute or the ordinance is ambiguous. There's nothing at all ambiguous about the terms of the county ordinance. The second is the only cases, like Curtis, in which this court has considered the statutory title is to reinforce the plain reading of the statute itself, the text. In that case, the court expressed the maxim nascitur associus and observed that in the body of the statute, there's a distinction between costs and bonds. That same distinction, the court then observed, was in the title. That's how a title is used. The title does not alter or change or expand the meaning of the text.
But the text refers, I'm looking at 25.4-16.1A, in addition to registering the owner of any short-term vacation rental which operated outside of a permitted zone prior to a certain date shall obtain a permit. So there are references to short-term vacation rentals.
As a defined term. And so as the Land Use Commission conceded, or as the county conceded at record 1017, short-term vacation rental is a term of art. Different counties define it differently. In Honolulu, is traditionally less than 30 days. On Maui, it's less than 180 days. Plus, they also look at whether the person occupying it has any other address. On Kauai, it's less than 181 days. Under state law, for purposes of the transient accommodation tax, is defined yet a different way. So there's no universal understanding of STVR. It is a term of art. And the county conceded that what it was asking the Land Use Commission at 1017 was that its particular term of art, 31 days with those two other elements, was unlawful as of June 4th, 1976.
If your reading of 205-4.5 is right in terms of farm dwelling, why did the legislature need to add in subsection 14, agricultural tourism as including overnight accommodations of 21 days, subject, however, to having bona fide agricultural activity being related thereto?
Because of exactly the question that Justice McKenna and the Chief Justice asked me. Does the farm dwelling requirement still apply, regardless of how long it is rented? That addition of the use allows a use entirely separate from a farm dwelling. So in that permitted use, the connection to farming, located on and used in connection with a farm, or from which the family occupying the dwelling derives agricultural income, is not found. It's completely missing because the legislature is introducing a new use. We're not advocating for the introduction of a new use. We are saying that as of June 4th, 1976, the legislature did not regulate how long a farm dwelling may be used. and therefore the county could not reach back in time and refuse to grandfather existing uses. It could still enforce the law. It could still require that every single property in the county of Hawaii is used as a farm dwelling. It has always had that power. That power was not added to or abrogated by the ordinance or the LUC's ruling. It has that power today, and it had it on June 4th, 1976.
I'm starting to have difficulty understanding then what this case is about, because it's my understanding that you represented, or your client represented, that didn't make a representation as to the use of the before the ordinance. In other words, I thought it was represented that we don't know how it's being used.
What was represented is what was petitioned to the county for the non-conforming use certificate, and both presented in the same set of facts, was that my clients have properties located on agricultural land. They were renting them for less than 31 days prior to the adoption of the ordinance. They intend to continue renting them for 31
What
days.
purpose were they renting it for?
The purpose is not developed in the record because the purpose wasn't relevant to the LUC's proceedings, just as the purpose was not relevant to the county's petition. We petitioned on the same ordinance, 18114, asking the same question. As of this specific date, is the use that is now unlawful under that ordinance, renting less than 31 days, was that unlawful as of that specific date that the county selected? That is the only issue that was ever an issue before the Land Use Commission.
And didn't the LUC rule based on the statute, not based on the, didn't the LUC say that it was illegal under the statute?
What the LUC did, I would submit, is two things. First, it said that it could not interpret or compare the statute and the ordinance when the Rosehill petitioners asked it to, findings of fact 76 and 79. When the LUC asked it to at 80 to 82, it did exactly that, compared the text of the statute and the text of the ordinance. So the first thing it did was treat petitioners in exactly the same position, asking the same question differently. And that's what the circuit court concluded as well. The second thing it did was to effectively adopt as a universal rule that as of June 4th, 1976, no farm dwelling may be rented for less than 31 days for any purpose at all, regardless of how it's used. And the record is replete with questions to the county asking whether it matters how it's used, for vacationing, for farming. And each time the county says it doesn't matter. All that matters is how long it's rented. And so if we come back to the questions of construction that the Chief Justice asked, my last point would be that below, in the proceeding before the Land Use Commission, the county conceded that nothing in the statute regulates the duration of rentals. That's at record 301. Despite the plain language of the statute, despite the reference to leasing in the statute, despite the absence of anything in the statute or legislative history that regulates duration as opposed to use, and despite the county's own concession that the statute does not regulate use, the Land Use Commission still granted the county's petition, which asked that according to its definition, 31 days, the Land Use Commission conclude that STVRs are illegal. That label applies, that term, I should say, applies regardless of the label. It is not a nuanced ordinance, and it is not a nuanced ruling. If it's less than 31 days, regardless of the use, it will be illegal. And so, if we
Your
think
position is under the LUC ruling, and I'm going to ask Mr. Chin about this, under the LUC's ruling, if a farmer leases his or her farmhouse to another farmer who is going to farm that farm, they're not going to be able to do that. That's what the LUC held,
that's clear,
if it's less than 31 days.
That's clear from colloquy with the county at record 320 and 325.
Is it in the findings of fact and conclusion?
And so coming back to Justice McKenna's question, I think it's in the findings in two places. One, those paragraphs that I cited to you, 80 to 83, where they compare the ordinance and the statute. And the second is in granting the county's petition. We have to look back at what the county asked. And if you look at the county petition at 5 and 107, or 1017, record 5 and record 1017, the county asked the LUC in its petition to determine that STVRs, as the county defined them, were in illegal use as of June 4th, 1976. The county definition, as we've talked about, makes any use, regardless of how the property is used, illegal if the rental period is less than 31 days. That is the effect of the LUC's order.
When you say the county's, that's the county's verbal definition or council's definition, or in some?
It's in the ordinance. It's in the ordinance as the ordinance defines STVR. So, Chief Justice, those are the elements we went over, that it's not owner occupied, that it's 5 or fewer bedrooms, and that it's leased for 31 days or less than 31 days. That is all that makes a property in STVR under the county's definition. And so to your question, Justice McKenna, in granting the county's petition, that is the LUC's ruling, that that definition of STVR is illegal, not just going forward, because the county didn't regulate only from the date of the ordinance forward, but going backwards to June 4th, 1976. It is a universal rule based entirely on duration. I would submit that there are 2 ways to approach the substance of it at this point. The first and most narrow is to reverse and remand and instruct the Land Use Commission to answer the questions that are actually before it and to treat each petitioner raising the same question in the same manner. The fallacy, or the fantasy, I should say, that has been perpetuated through the appeal is that petitioners asked the Land Use Commission to bless particular uses of their property. They did not. In all circumstances, petitioners acknowledge they need to be used as farm dwellings. The county could have enforced for the last 5 years, could have enforced for the last 40 years. They all must be farm dwellings. The only question is whether the county ordinance 18114 duplicates what was already the law as of June 4th, 1976. If it duplicates it, if the state law already regulated farm dwellings in the same manner, not more restrictively, then all the county has done is codify an ordinance, what was already the law. If the county has been more restrictive, if state law did not regulate use, then the county has reached back in time and prohibited a use, the rental term, that was not previously unlawful. So the court could remand. The second thing the court could do is reverse and grant the Rosehill petitioner's petition, as the circuit court did, concluding that under the plain language of the statute, there is no regulation of the duration of the rental, acknowledging, as the circuit court did, that this is not about whether the county has taken property or violated due process or done anything else illegal, acknowledging, as the circuit court did, that this is not a political question, nor is it about vacation rentals. It is simply a question of statutory interpretation. And on that note, if I may, Justices.
Let's go back to that point. So your position is that it doesn't matter. Again, the purpose doesn't matter. The statute would allow for any purpose as long as it's a rental and it's of a farm. It's still a farm dwelling.
So let me
understand. I'd like to understand exactly
step by step, Your Honor. I appreciate the opportunity. Under the state statute 205, purpose matters very much. That's all that matters. Located on a farm, used in connection with a farm, or the alternative, occupied by a family that derives income from agricultural activity. That is the definition as of June 4th, 1976, and it's pretty close to the definition today. Today, the legislature has substituted in connection with for accessory to, but otherwise, those 2 elements, one of them must be met. Unequivocally true. When you turn to the ordinance, the county ordinance, use doesn't matter at all. There is not one word in the definition of STVR in the county ordinance about how the property is used or who occupies the dwelling. Contrast that with Maui County. It is entirely focused on the duration of the rental, which is why the county represented to the LUC that a vacationer vacationing in the dwelling for 40 days is lawful under the county ordinance. That's at record 313 and 846, and why the county represented to the LUC that a farmer renting to another farmer for the purposes of farming for 29 days is illegal. And that's at record.
Can you clarify for me what relief you requested before the LUC again?
We asked the LUC to declare that as of June 4th, 1976, State Statute 205 did not regulate the length of the rental period. That is all we asked for. In effect, like the county, we asked the LUC.
But at the county, you had requested a non-conforming use certificate for a vacation rental.
Only under the county's label, Your Honor. The only thing that made it a non-conforming use, the only thing, Your Honor, to be absolutely clear, the only thing that made it a non-conforming use was that the rental period was less than 31 days. The county's non-conforming use certificate process, and this is in the record, does not ask how the property.
Did you represent that that the rentals, the past and continued rentals were for farming purposes?
The county required no such representation. It is purely durational. If the duration is less than 31 days, you needed a non-conforming use certificate.
And the LUC has not passed any regs regarding time periods.
That is true.
But of course, if they did, this would be a different argument.
They would apply prospectively. They would apply prospectively. This is applying retroactively. If I may just briefly touch on some of the arguments.
What is the issue with respect to retroactivity? What is the concern here?
So,
that you would be divested of income? I'm a little confused.
Certainly, Justice. Happy to address that. So beginning in the Supreme Court decision in Waikiki Malia, in a bunch of other cases, the court has recognized that that the use of a property cannot be changed retroactively. In other words, if someone is using the property on a particular day and the next day the legislature says that use is illegal, it may do so, generally speaking, but it may only do so prospectively. It cannot say that you, who were using the property that way, are not grandfathered in to continue using the property in the manner that you were using it. It's the continuation of a non-conforming use, which is why they were called non-conforming use certificates. To continue a use, rental for less than 31 days, that the county has now made illegal. That is the issue here with reaching back in time. It would violate the Constitution unless the county.
But wouldn't there need to be some sort of representation that you're requesting a non-conforming use for a short-term rental that is for farming purposes?
Not at all, Your
consistent
Honor.
with the land use?
Not at all, Your Honor, because the county ordinance did not require that to make it a non-conforming use. It wasn't the rental for vacation purposes that made it a non-conforming use. It was a rental of less than 31 days that made it
Your
a
clients,
non-conforming.
representative, will you represent that you're only talking about rentals to folks who are going to farm on the land? Because I'm hearing everything you're saying. We're looking at the statute back in 76, and are you trying to get us to say that any kind of lease is okay, or only a lease for farming purposes?
Only a lease that meets the definition of a farm dwelling.
Meaning
Used on, located on, and used in connection with a farm, or in which the family that occupies it derives agricultural activity. That definition is unaffected by any request that we would have. All we have asked is for an interpretation of the law as of June 4th, 1976, specifically whether it imposed a minimum rental period, not at all affecting the provisions as to how it must be used, true then and true today. If I may just briefly touch on a couple of points that were raised, and then I'll close, if I may, with jurisdiction. Council has argued putting aside the labels of vacation and adding a new use, which are roundly inaccurate representations of our petition and the record, that things like the LUC's definitions should inform, definition of single-family dwelling, should inform the outcome here. The LUC, I see I'm out of time.
But you can wrap up quickly.
Thank you. I promise to take, if 2 minutes would be acceptable.
That sounds about right.
Thank you. The LUC did not use its definitions in its order. It's impossible to defer to something that the LUC did not do. The second problem is we only defer to the LUC in terms of agency decisions and interpretation when the statute itself is ambiguous. The LUC did not determine that the statute is ambiguous, and nor is it. There's no finding anywhere that it's ambiguous, and nor is it. The third problem with resorting to the definitions to aid the LUC's interpretation is they actually don't add anything. A single-family dwelling is defined as one dwelling unit. That's distinguished from multifamily, meaning two or more attached dwelling units. It's to be occupied by a single family, meaning only that it needs a kitchen. One kitchen can't have two. It deals with the structure itself and not with how it's used. How it's used is entirely left to 205. The last point, just briefly on jurisdiction. We believe that jurisdiction is addressed in Waiʻi. In that case, of course, the statute changed to divest this court of direct appeal and place it in the hands of the ICA. The appeal was taken to this court instead after the statute had passed. The court in that decision interpreted the statute, concluded that the ICA was the appropriate body, and sent it to the ICA in a transfer nunc pro tunc with an order to docket it as of the date of the filing of the appeal before the Supreme Court. Here, the Supreme Court has already accepted the transfer. All that's left to do is docket the appeal as of the date that the appeal was timely taken. All of the cases that they point to from Hawaii in which the appeal was dismissed either involved an untimely appeal, which we don't have, or an argument that jurisdiction, subject matter jurisdiction, was somehow waived by a party through an argument. And the court observes you can't waive subject matter jurisdiction. In all other respects, we are on all fours with Waiʻi, and it furthers the court's policy of having appeals decided on their merits. It also affects a number of other appeals that are pending both before this court and before the ICA. Thank you.
All right, thank you, Mr. Chip Chase. Mr. Chin. And I gave Mr. Chip Chase a little extra time, so I'll give you another 2 minutes if you need it.
I'll do my best. Thank you very much. I'll address Chief Justice's question about are there possible ways for a farmer to be able to lease to another farmer? Yes, within the parameters of 205-4.5. So for example, the ability under 205-4.5F, there is a specific provision that allows for lease. It's not month to month. It isn't. It's much more long term. But that's an example of how the legislature worked out the ability to be able to lease under situations like that for agricultural uses. It doesn't have the same flexibility that I think Mr. Chip Chase would like for all of his clients. But that's the whole point of the agricultural district, is that it starts as a default, which it's agriculture. It's not the urban district. It's not even the rural district. This is the agricultural district. And so the people who are on this district are either employees or people who are serving the farm or deriving income from the farm, or they're visitors that are there under very specific circumstances. Another point that I wanted to make had to do with, I think Justice Ganoza, you had mentioned the fact that that would petitioners now be able to go back to the Land Use Commission? The answer is yes, they can still get a special permit, right? In other words, a use is not permitted as of right. However, they still have the ability to be able to pursue what they want by a special permit route. In fact, the Hawaii County Code has an ordinance that allows for the special permit process to be granted for bed and breakfasts in the agricultural district, as well as guest ranches, which frankly is how many of Mr. Chip Chase's clients advertised their property as a guest ranch. And so there is an ability for them to do.
Ranch?
Yes, yes.
That's in the record?
Yes,
Okay.
in fact, it's cited in our opening brief, and it's also under Record on Appeal 89-118. And I think this will actually segue into the next point, which was why did the Land Use Commission struggle to even hear Mr. Chip Chase's client's petition? And it was because of this. It's because not only were they not getting answers, just like counsel did not answer Judge Castagnetti's question. Not only were they not getting answers about how the farm dwelling or the short-term vacation rentals were being used, but what they were getting was advertisements, and this is in Record on Appeal from 89-118, and it's cited in one of our footnotes, that described their properties as the ideal solution for a multi-generational vacation or retreat, or 6 to 7 bedroom vacation rental, a perfect setting for special events or family gatherings. The words that are missing from all of those advertisements are farm and agriculture. The words that are in those advertisements are wet bar, indoor sauna, private tennis court, and media room, which can convert to a 7th bedroom, which wouldn't even fit within the definition of a short-term vacation rental. The word mango is in there, but it's not for mango tree, it's for mango sunset. But that was the clients that was being the Land Use Commission was looking at when they were examining the Rosehill petition, and that's why they asked the questions that they asked.
But I think you just answered my question. But to be clear, that is in the record before the LUC.
It is in the record before the LUC. Thank you.
Mr. Chipchase says that his clients came with a very specific, narrow question, and his argument is it's not apparent why the LUC wasn't able to answer that one narrow question, as I understood it.
Sure. I think first of all, the Land Use Commission has their rules, and the rules was that they shall deny, if they find that the petition is speculative or hypothetical. And under Citizens Against Reckless Development, there is an ability for commissions, either because of the lack of resources to be able to answer a question, or because they don't, because they're concerned about whether or not they are answering the question properly, to make sure that their decisions are based upon a specific factual question. Specific factual question comes up in Land Use Commission Rule 15-1598, as well as 15-15-104. The order that is issued by them has to be based on a factual situation. And what Commissioner Okuda said on the record was, he said, there's simply not enough facts or evidence to make a declaratory ruling. There's a danger that if we make such a ruling on an incomplete record, the ruling itself leads to unlawful or improper results or consequences. And so that's why they declined. Essentially, they were like the tribunal that was answering a declaratory order. They were asking questions of counsel, and counsel said, no, I don't want you to focus on that at all, because that's not relevant. In fact, in the Land Use Commission proceeding, it was you're being arbitrary and capricious if you do something like that. Instead, I only want you to focus on this one simple question. The Land Use Commission wasn't going to do that. So that just brings me to I think the final amount of time that I have, which was, what was the Land Use Commission's analysis here? And why is it that they excluded short-term vacation rentals? First, the factual situation that was in front of them was not just short-term vacation rentals as a concept, because it is varying among different counties. And may I please just finish?
I'll let you finish your thought.
Okay. It wasn't just the concept. It was Ordinance 18-114, and the specific factual situation was that people were applying under Ordinance 18-14 for non-conforming use permits and the ability to register as a short-term vacation rental. So the Land Use Commission, I think, did two things. They, in their findings of fact and conclusions of law, they compared the elements of a short-term vacation rental under the ordinance, as well as the elements of a farm dwelling. And I think in the first finding that they had, it's not the first, but the first of my topics was that a farm dwelling has not included the short-term vacation rental usage in the statute. So just a strict reading of the statute. The ideal thing, what the legislature could have done, is have farm dwelling, and then it allows for short-term vacation rental use, just like the agricultural tourism activity reads. And we are all supposed to understand our statutes and read them all together for a harmonious and sensible result. Last point is simply this. The other thing that they did is they did take a step back. They didn't just offer a blinkered-strained analysis in terms of, we're just going to look at this one issue here. We're going to step back and see, what is it that we're talking about? We are talking about a short-term vacation rental program in Hawaii County, where if we rule in a certain way and answer their question or decide that short-term vacation rentals are included as a usage within farm dwellings, will allow people to go to the Kona office and sign up and get their non-conforming use certificates, which is ministerial and requires no notice to the public, no public meeting, no environmental assessment, no water study, no cultural study. They can just be able to do that. And that was the concern that the Land Use Commission had. I think my time has expired. Thank you so much, and thank you to my colleagues.
Thank you to both of our counsel today. The court will take this matter under advisement.
E ku iluna, please rise. Ua ho'oku'u ia mai ne ke aha. Ho'okolo ki ke hano o ka moka'aina o Hawaii. This Honorable Supreme Court of the State of Hawaii is now adjourned.